All right, everybody, welcome to the Ivylaw Law Office weekly Q&A with myself, Wilberforce Adjunct, and
You're welcome, Jumoke Oladapo here.
here we go. Today, we're going to talk briefly about Maryland wills. So, most of you know what a will is, and others may not. So hopefully with the next few minutes, we can tell you as much as possible about Maryland wills. I'm gonna ask Attorney Jumoke, who's licensed in Maryland and practices estate planning as well as immigration, but estate planning is one of her specialty areas. So I will be asking her questions about it, and she will give us some information. Beyond what we give you today, if you would like more information, feel free to call our office and check our website and come see us for help with any estate planning or needs. And Jumoke will be more than happy to assist you. Okay? All right. So, with that said, first question, Attorney Jumoke. What constitutes a valid will in Maryland?
Thank you very much for that question. A valid will in Maryland has to be in writing. It has to be something that the testator, that's the person that is creating the will, does in front of two witnesses who are uninterested. And it has to be attested to by the two witnesses in front of the testator and each other. It has to be such that the testator also needs to be an adult. That means over 18 years of age. And that's it. Basically, you create a will in writing before two witnesses who sign before you and you sign before them.
All right, thank you. And it's a holographic, which is a handwritten will. A handwritten will is legal in Maryland?
Yes, it's valid in Maryland, but it has to meet the requirements that we said above.
Okay, so you have to check the requirements before you try to do a handwritten will, the additional requirements, right?
Oh, okay. Definitely. But yeah, there could be side effects to having a handwritten will, but yes, it's valid if it meets the validity criteria.
All right. And what is the procedure to probate an estate with a will?
All right. So if someone dies in Maryland without a will, that means the person dies intestate. And if someone dies with a will, then the person did not die intestate. And what they have to do, someone who is either an interested person, a spouse, or a family member will have to open an estate for the person at the registers of will of where the person is domiciled. So if the person is living in Maryland, at Prince George's County, for example, you have to go to the Register of Wills. Someone will have to go to the Register of Wills to open an estate on your behalf. So if the decedent died with a will, then you'll have to take a will, last will and testament, the original will have to be presented before the Register of Wills, also the death certificate. There are other list of documents that will be asked. For example, the funeral bills and expenses will be asked. And if you have vehicles, you'll present titles to such vehicles. If you have real property, they'll want to ask for documentation about the value or assessment on the real property, or the appraisal value of the real property, and a whole lot more. So anything basically that is in your name solely will be taken to probate court, or anything that you hold as tenants in common also will be taken to the probate court. Also, you have to pay the fees, probate fees, as well as when you get to the probate court, then the officer will have to to determine whether you're going to open a regular estate or a small estate. A regular estate will be $50,000 and above in estate. If the person died without like heirs, and if the person has a surviving spouse, there is a sole heir of $100,000 will constitute a regular estate. If your estate is lesser than $50,000, then it's a small estate. So those are some of the things you need to know when going into the Register of Wills to open an estate.
Thank you for that. And what if the decedent that didn't have any assets? Does the will still have to be filed?
So a will still have to be filed if you died with a will without any assets. Yes. So it's not just about assets distribution. You still want to look at what it is that the will says, so that if there's anything to be administered, like bills to be paid, such will be paid. And any other thing will be done.
All right. And when does an estate have to be opened?
An estate is usually opened upon the death of the decedent, and it could be opened within 6 months of the death of the decedent. If you have a property, there is no assets cannot transfer without it going through the probate court. So it's better that you have an estate opened if someone has some properties or assets.
And okay, how does one get the letter of administration for the estate?
The letter of administration is usually received, with the process of opening an estate. So you have to petition to be a personal representative with the Register of Wills. And once that is granted by the court judge, then a letter of administration will be received by that person so that they can act on behalf of the decedent in the administration of their will or administration of their estate.
Okay, that's good. And who are usually those people that can get those letters?
So the popular ones are surviving spouses, we've seen children. I'll say any interested person can, and also an attorney can.
Oh, okay, that's good. All right, and where does one have to file an estate? Where do you file the estate?
You open an estate in the jurisdiction where you domiciled. So where you live basically at the time of death is the proper place to file.
And is probate necessary in a small estate?
So as I said earlier on, if your assets is less than $50,000 is a small estate. So yes, you need to open a probate if that is the case and you have an asset that is valued more than your debt. So, but if your debt is more than the asset value, then not necessarily. Well, even if you file, they're going to close it out at some point saying there's no assets to probate.
Okay, good. And what if the only property in the estate was jointly owned? What happens then?
Okay, so if you jointly own a property, let's say, and this happens a lot when you have spouses owning homes together, usually a jointly titled property automatically transfers to the surviving owner. However, you have to bear in mind that there could be inheritance taxes due where it's not like the surviving spouse. Let's say it's a brother or aunt, or depending on the relationship to the decedent, there may be inheritance taxes due.
Right. And what if the only asset is real estate? Does that have any relevance?
So I have people call me and when they say, oh, it's only a house that we have, or it's only a house that the person had. Yes, it's still relevant because a real estate is an asset. And even if it's not a real estate, if the person just has a car, yes, it's still an asset. So whether it's real property or personal property, it does not matter. You still have to open an estate.
Okay. And how about vehicles, motor vehicles? What if that's the only estate property remaining?
Yeah, so that's the same answer like I gave earlier on. Yes, if it's only motorbike vehicles, yes, you still have to open an estate. If the value is probably over $50,000, yes, you still have to do, that's a personal property. And if the ask and in addition to that, if the vehicle is only in that person's name.
Okay, great. So if they're in the title, it goes transfers outside.
Can you say that again?
I said if the person's name is on the title, then it goes to them outside of the will. Is that how that works?
So if it's only one person's name that is on the title and the person is the person that passed away, yes, it goes to probate.
Okay.
So anything titled in only your name.
Goes to the probate.
Yes.
If there's another name on it, then it goes to the other person.
Exactly. So if it's jointly owned, it goes to the other person.
All right. Okay. Thank you. And who distributes their estate's assets? Who distributes it?
So that's the responsibility of the person we call a personal representative. A personal representative is appointed by the court or by the Register of Wills when you make an application for that to happen. So a personal representative could have been chosen or nominated in a will. Or if that's not done, the person could step forward and petition to be a personal representative. And that's the person that will distribute assets and do other things that needs to be done about the estate.
Okay, so I think that kind of answers my next one. Are there any other duties of the personal representative other than what you just mentioned that we should know about?
Well, basically, they generally settle and distribute the estates, the pay for debt, the creditors, the sell assets, they distribute the assets according to the terms of the will or according to state law. And basically, they gather together or marshal together all the assets of a decedent and make sure that no asset is lost or every asset is accounted for, and presented to the probate court or the office or the Register of Wills. Also, they have to pay taxes and also file inventories and accountants and information sheets. There are a lot of duties that goes with being a personal representative, and those duties need to be fulfilled. So some people think, I've seen a situation before where someone that was nominated as a personal representative thinks that means she can spend the dissident's money, or she's in charge of the dissident's money, and that means she can spend it for personal use. No, it's the dissident's money, but you administer it according to the terms of the will, according to the state law, so that the people that are entitled to it get it, and so that all debts and taxes, funeral expenses, and everything is paid. So it's important that you know your role. It's a fiduciary role if you pick up the task of being a personal representative, and it's important that you know that it has to be done according to what the law says. It could be a tedious task for a lot of people, so you want to reach out to an attorney. We do this every day in our practice. Reach out to an attorney to help you probate, be a person, you represent you as the personal representative, file all the legal documents necessary, do the accountings necessary, and take the load off your head. As a personal representative, a lot of them are related to the deceased, so it's a whole lot of task trying to administer probate while grieving. And this is so important that as much as possible, you want to let someone who's a professional take this and get it done properly, because there are a lot of timelines to these things. Let an attorney, an estate planning attorney or probate attorney help you to administer the estate if you're nominated as a personal representative and you know that you cannot get this done by yourself because you're grieving or because you're not that competent.
Fantastic. And what if in the event that a named personal representative wishes to be removed from the role? What happens in that instance?
So if someone who has been nominated or appointed as a personal representative is no longer interested and wants to be removed from the role, they have to submit a written application to the court, a statement to the Register of Wills, and they'll be given 20 days notice. They will give 20 days notices to the interested persons. And if the interested persons are okay with the person being removed from the role of a personal representative, that will be done.
Great. All right, so I think we've come to the end of this Q&A session for estate planning, Maryland wills with attorney Jumoke Oladapo. So now you can let people know how to reach you and what you can do for them if they need your services, please.
All right, so I'd like you to reach out to us. Our office is Ivylaw Law Office. We're based in Greenbelt, Maryland. We'll serve people all over Maryland state. If you have a probate issue, if someone just passed away that's a loved one, or there's a will and someone nominates you as a personal representative, we're here to guide you. We're here to advise you. We're here to help you through the probate process. Don't do this by yourself. You need some advice, you need some help, particularly if the decedent died with a lot of asset that needs to be distributed. Let a professional, an estate planning attorney or a probate attorney help you with the estate administration. Also, if you have a trust left by the decedent, we can do trust administration for you as well. So reach out to us. Our office is Ivylaw Law Office. Our phone number is 301-276-0887. We can be seen on the website, ivylaw.office.com. We're on Facebook, Ivylaw Office. We're on Instagram, we're on Twitter, but we'd love to help you. Our goal is to provide you with quality legal representation. We provide excellent services and good client services, and we will just love you to reach out to us so that we can help you with your probate needs.
All right, you heard that from attorney Jumoke Oladapo. So please don't hesitate to reach out. You have something to say, attorney?
Yeah, and also we'd like you to subscribe, like, share this video with others. If it's helpful to someone, or if you know someone that will learn from this, share, like, subscribe, and let's grow our social media family.
All right. Oh, also you have a live seminar coming up, right? Tell us about that.
Exactly, that's true. On June 30, we're going to be having an estate planning seminar. It's going to be live. It's going to be appetizing estate planning, what you need to know about estate planning, and also the mistakes that people make when it comes to estate planning. It's time to come out live, meet with us, ask us questions, and also we get to know you better and be able to serve you. So it's going to be in Greenbelt, and we hope to see you then, June 30 at 6 p.m.
All right. So look online on our Facebook page as well as Eventbrite, and you will find the registration information in the next couple of days. and we hope to see you. And I'm sure Attorney Jumoke will be very helpful to you when you show up. Okay? All right. Thank you all for joining.